Thursday afternoon, the 16th of January, and we have saved the best for last. Don't tell all the other witnesses that I said that on the issue of juvenile justice, and welcome Attorney Kim McManus. Welcome back, I should say.
Thank you. Good afternoon. For the record, my name is Kim McManus. I'm with the Department of State's Attorneys and Sheriffs, and I appreciate having the opportunity to come back. I was listening earlier and I heard there might be some concern that there could be a little repetition here. And so I will try my best not to be repetitive. I was thinking throughout the day, sort of refining what I had originally done, since I was supposed to be one of the first witnesses, now I'm the last, for this 2-day piece. So I was kind of kept changing things as testimony was being given. And I was thinking, the natural reflex for someone with a prosecutor background, or I would say any attorney, is that by being the last one to go, we would want to sort of snipe and pull out all the mistakes or what we perceive as mistakes or misstatements that have been made. And I'm going to resist that urge, because my understanding, again, for this 2 days is to really just give you the lay of the land from our perspective. I will reserve the right to make any of those arguments or corrections next week when we meet again, specifically where folks will be arguing more, right, about how they feel about, not how they feel, how they think, maybe how they feel about raise the age. So I will point out a few discrepancies as appropriate, but I'm really staying away from correcting what others have said. From hearing your testimony, I just want to set the table on one other issue. I know there are a lot of questions about prosecutorial discretion. And when I go through what I had prepared, there's definitely pieces in there where I will happily explain what prosecutors are thinking when we're making these decisions, what we're weighing. But what I would appreciate, if it's possible for our time today, is not to have to defend the concept of prosecutorial discretion.
There'll be other opportunities.
No, exactly. I will happily come back to do that. I can brush off my separation of powers doctrine presentation. We can dig deep into the Constitution and our history and how we are here where we are. But if we cannot dig into that today, that would be wonderful.
Until you all think we're impinging discretion.
There we go.
Maybe we won't.
And that's exactly. We may not have to tread on that ground, but if we do, we would definitely be happy to engage in that conversation. All right, so getting into today, I really appreciated Attorney Paul this morning. Paul, I think I said that right, stating, rule follower like me, that he was running through the scenarios as I had told you yesterday that had been my plan. He did an excellent job walking you through how a case rolls through, right? Whether 17 or 18, how those misdemeanor cases are petitioned into family court and the process that goes through there. I'm not going to go through all those steps again. And I jokingly, right before we went on the record, was asked if I'm going to show the chart, all the various charts that you have in the last day and a half. I am not. There will be no chart put up there. But I think just knowing, right, that everybody has a chart, that everyone who practices in this area, even for years, is always double checking and going back and making sure, is this the right, which path? Like, where can I go? What can I do? What are the options? We're always checking the statute and running through that and creating, I'm more of a flow chart person than a chart. I started making a flow chart for you all. It turned into a big spaghetti mess. I was like, that's not going to be helpful. So it is complicated. But here we are. So rather than going through exactly how Marshall went through everything, I'm just going to highlight where we are seeing in the process issues of accountability and engagement in our work with our 17 and under jurisdiction versus our 18 plus juveniles. Like that's the pinch point that you all are wondering about, right? We see what's working, 17 and under. we're wondering what is or isn't working with the 18, 19, 20 folks who are considered juvenile delinquents. And by our work, I mean not just prosecutors, but the judiciary, defense attorneys, DCF, community resources, all the persons and entities involved in working with these juveniles. Really important that I did not just say DOC yet. Department of Corrections is only involved in youthful offender cases, not juvenile delinquency cases. And it's really important when we're talking about 18 and 19-year-olds in the juvenile justice context that we don't conflate juvenile delinquents with youthful offenders, right? You've heard a lot about this, but it's even as folks are talking about it, sometimes things start to meld together. And so as much as possible, you need to keep separating those categories, right? DOC is not involved with our 18, 19, 20-year-old juvenile delinquents. Only DCF is involved, and only DCF is providing supervision. So while I said I would not march through the process, I do want to start with citation of a juvenile, whether 17 or 18, into court. There was, and this is be one correction or just one statement that I want you to weigh against some others that were said today, about the speediness potentially of the delinquency process versus the criminal side. And we would push back on that a little bit. And I don't have a whole data set for you to support that. So I'm pushing back gently just to put a flag in that, because what the process, and it varies by county, but a juvenile has a contact with police. There's a citation alleging what would be criminal conduct. If that person was an adult, they say you're cited into court. Most of those citations are from anywhere from 4 to 6 to 8 weeks after the behavior. We have a limited ability for emergency situations. If the juvenile, if their safety is a concern or the safety of the community is of such a concern, that we can do something called a flash cite, where we can bring someone in within 24 hours of contact or the next business day. But apart from that, juveniles from the moment of incident for their first appearance in court in the land of juveniles, that's a long time. So just note that for the first step in.
And that is for going into a citation into family court.
Yes.
And I just want to, that there are other options that could be, if it's a incident that's a fit, it could go to pre-charge.
Absolutely.
That could be seen within days.
Possibly, depending on that, that program's, how they're bringing folks in. So absolutely.
Okay.
So this is just talking about getting into family court.
Okay.
And to be fair, that citation, on the adult side, adults are cited into criminal court. Again, depending on that county, that's 6 to 8 weeks out, but for certain situations where you're allowed to in earlier. But I did just want to point that out for the committee. You all have heard and discussed the risk assessment, the Yazzie screening tool. I won't get into that, but only to say for the prosecutors, it is a tool. Every tool has its pros and cons. Another tool would have another issue, no doubt. We do find them useful. They collect a lot of data for us, but they sometimes are missing things. And that is where you heard Judge Sone speak about how the state's attorney has discretion there, that even if a low or moderate risk if the Yazzie screening tool states that a juvenile is at low or moderate risk and suggests diversion, a prosecutor can essentially override that. The example I'll give, and this is a moment of prosecutorial, gosh, that's hard, discretion is, and I know this landscape has changed a little bit, but when I was a DV prosecutor a few years ago, we could not send domestic violence cases to diversion, even when I wanted to, even when the fact pattern would show that this was more sort of a situational act of violence that was indeed domestic violence with a household member or, a boyfriend, girlfriend type situation, they would not take the case. So even that Yazi said low or moderate risk, I could not send it. And then I would even have conversations, this has changed, but this is a few years ago. And I would have conversations with diversion of, well, what if I changed it to simple assault? Like, will you take it? And they're like, no, because the affidavit shows that this is, intimate partner violence or household violence. So only to say that sometimes when we're using our discretion, I think there tends to be an assumption that we're using our discretion to push things up. And that's not always the case. Sometimes we're trying to move things in a different direction and are not able to.
Representative Goodfriend,
Yes.
you can.
Maybe you just answered it, but why would you take that abuse like that and want to send it to diversion? And maybe you just answered it, but just give me a little more clarity because I'm.
Absolutely. And I sort of flew through the phrase with domestic violence. We will sometimes see a situation of violence that is more under the umbrella of what we would call situational violence, meaning, and again, we're talking about juveniles here. I'm not going to extrapolate to adults, but teenagers they're drinking and someone just found out that somebody cheated on them, right? Emotional outburst versus the domestic violence that we see that shows the power and control dynamic, right? That embedded violence. That's very different, right? How you are going to work through that. The first one could be appropriate depending on the facts and circumstances for diversion. The second one, much more complicated, right? And would need a more nuanced approach to wrap around that juvenile. So that would be just an example.
I understand where you're going with that.
Yeah.
Thank you.
Not a problem. So the Yazi has occurred. If the prosecutor decides to not divert the case, but to file the petition in family division, one important difference, and then again, I believe this has been stated, but it's important to underline, for 17 and under, the court is going to make sure that there is a parent or guardian involved. And if not, appoint a guardian ad litem or appoint a guardian ad litem in addition to the parent and guardian, right? To help wrap around and help in the general process of holding that juvenile accountable. Once a juvenile is 18, their parents are not required to be there. They do not have access to that guardian ad litem. There's probably a few exceptions to that if there are some developmental issues, but barring that, you're not going to have that additional adult presence for the juvenile once they turn 18. Conditions of release. So juvenile comes in to the preliminary hearing. They hear what the charge is, and then there's going to be their next hearing is going to be scheduled out a few weeks, and so the judge may provide conditions of release. What the juvenile can or cannot do, I should say, between now and the next hearing. The statute says may, and we know that some judges interpret that statute in a way where they don't think they should provide conditions of release. So some judges do not do that, some do. It is inconsistent across the state.
So is there something we need to do about that, or is that training of judges?
I think it's just something to note. And again, when we talk about the differences for youthful offender, that's an interesting difference. And not that it's written differently, but just from practical experience, youthful offenders, conditions of release are pretty regular. And there's another piece there about when it comes from criminal court over that I'll discuss later. But just something to note that sometimes juvenile delinquents do not have conditions of release.
Tom, I believe that's. a question.
Yeah.
Oh, sorry.
What would be a good example of a youthful offender or whatever for, they are not following the conditions of release, repetitively disobeying?
So now here's where we need to be careful. A youthful offender
so no.
or a juvenile delinquent?
Juvenile delinquent, or
Okay.
juvenile delinquent, yeah.
So what would be examples of them not following conditions? of
Yeah,
release?
what would be the sanction if they're issued
Right.
conditions of release saying you can't do something and they continue to do it?
Right.
Is it just an upgrade in whatever the plan is, or?
Well, right, because this is during the time period where there is no plan yet, right? So this is in between hearing about the initial charge and then the merits hearing, which would happen down the line. So if a child was not following the conditions of release, we could petition, it's a new petition to the court, a violation of condition of release, which, you know, that would be an adult criminal charge if it was an adult. So we could start a new petition. It would go in front of the judge. Juvenile would come back in front of the judge. Judges would read the petition and set it for a date. And then those usually start stacking up together with the original petition. The judge might issue additional conditions. And again, here's an important distinction. 17 and under, there are more options. If a juvenile is not following those conditions of release and there's some larger issue going on in that child's life and the parents are not able to sort of, you know, say it's a 24/7 curfew and the child keeps not following that curfew, right?
Situation
Exactly.
because the
There's-
parents are failing to help. Okay.
Right, so then there's other pieces there that might be able to kind of correct in that space. 18 and over, you're not going to have those tools for those conditions of release if there's
So it
violations.
could be more effective than the adults.
Well, for the 17 and under delinquents, yes, the DCF has tools, more tools. Once the delinquent, again, we have delinquents who are 18, DCF does not have those tools,
The
right?
only
Can't
thing you
hold
could do
them.
is increase strength of the conditions or set bail.
They cannot, it's a delinquent case. There would
No,
be
but I mean, if they
bail.
were an adult,
If they were an adult.
that's what I said.
Oh, I
Yeah.
apologize. Yes, that would be, right, there'd be differences there of additional conditions.
At what point, just following up with Tom, at what point would you go to as far as having custody established with DCF and then DCF could actually detain somebody in that situation?
I'm sorry, can you say?
So I heard from Marshall this morning that, you know, if they keep on violating conditions, that eventually they can seek custody, that given to DCF,
Mhm.
and then DCF could actually detain, you know, send the person into detention, I should say, not detain like in prison, but sent to a secure facility, locked facility.
Remove them from the home, exactly,
Remove them from the home and put them somewhere else.
right,
So at what point,
for only 17 and under.
right, for only 17 and under,
Right.
what happens? Okay, so what, the first question is, at what point does that happen often? And at what point does the state's attorney, or is that really the discretion and it differs among the state's attorneys?
Well, and it's really depending on, you know, there's violating conditions of release and there's violating conditions of release. So, you know, if there's a very different conditions and some would require a different response. So say, for instance, and again, I'll use a TV example, a couple high school age, there's a domestic violence allegation, the juvenile alleged to have harmed his or her partner is not supposed to be within 300 feet of that person, right?
Yeah.
That and violates that condition, goes, you know, purposely goes over to that person, drives by the person's house repeatedly, that sort of violation would be different from, needs to be home by 6, right? And got home at 6:30. That's going to be treated differently. So I really couldn't say when would DCF or the state say like, whoa, things are so out of control, we need to move this person. I can say that my personal experience, that was very rare. Usually when children are being removed from the home, things are really just out of control. So yeah, it'd be hard to answer that. I think just the key distinction from our office that we want to make is, whether it's violating juvenile probation or violating conditions before we have a disposition plan, 17 and under, DCF has some tools, has some leverage with the juvenile to say like, hey, if we don't get on board, if we don't start doing what we need to do, like your life is gonna change, right? Your school might change. Like, there's some big things that could happen that a 16 or 17-year-old doesn't want to have happen in their life. And maybe that helps them to engage with our delinquents who are 18, possibly 19 or 20. If they came in as a delinquent at 18, DCF doesn't have that big tool, right? That there's no custody option. There's no, you're talking, you're trying to build relation. You're trying to convince folks to come along. You don't have an ultimate tool of any kind to correct that behavior. If they went through a criminal court, right? But
It was youthful offender getting.
and then, right, so then again, right, youthful offender, Department of Corrections and DCF are involved together. There are additional tools there. But for the juvenile delinquents, DCF is very limited once that person turns 18.
So when I hear there's lack of accountability, maybe for 18-year-olds, is that the concern?
That, yes, in a nutshell, what we're seeing is that, 18, 19, 20-year-olds who are under that juvenile delinquent umbrella. So like, now let's skip ahead. They have a disposition plan. They have a program that they're supposed to be working on with their DCF caseworker. Those are who are engaged and want to take this opportunity to have this person help them navigate this part of their life. It can work really, really well. Judge Zone, mentioned this, like, wow, you see someone 6-9 months later and you're like, you turn things around, like, and we all love that. Like, prosecutors want to see that too. That's a wonderful moment when you see someone who's been, messing around, to say it colloquially, and then it suddenly has a job, is going back to school, like, fantastic. The 18, 19, 20-year-olds who don't want to engage, who are the ones who probably need those services the most, if they don't engage, we can't make them engage. And we see that, and I apologize, I know there's a question coming. And I believe, I can't remember if it was Attorney Paul said, those who already have some resources and supports, right? Who have an adult, whether it's a parent or someone else who's in their corner, who's kind of pushing them like, hey, like make this work for you. They benefit. The 18, 19, 20-year-olds who, again, could really use this the most don't have some of those already existing supports, to have the encouragement of like, let's make the most of it. Let's use this to really better your life. And they can, worst case scenario, just run the system around, show up for court hearings, not show up for court hearings, meet with their DCF worker, not meet with their DCF worker. Anyone here who's worked with teenagers or young adults or has had any as your children, nieces or nephews, if they don't want to do something, they can really wear you out, right? All the excuses, all the, oh, I meant to do this, da, da, da. And then eventually they're going to age out of the family division, right? Depending on the age that their delinquency started. And then that is it. Nothing happens. They can just run that clock. And then the case is closed and it disappears.
I have some more questions on that, but I have Ian, Ken, and Karen.
Really briefly, so talking about the potential lack of accountability for 18-year-olds and essentially 19-year-olds as age goes forward. On the other side with the youthful offender, raise the age also could impact, if it went to 19 for felony cases, could be transferred, could be youthful offender. And in those instances, we've heard a lot about like a really significant incentive to like satisfy the probationary conditions, because if you fail, then you literally go to criminal court. You've lost your opportunity to make anything except go to sentence. So if for those cases there is accountability, so it's more like so we're talking youthful offender and juvenile delinquency. Both of those are going to be impacted by raise the age if that goes forward. And the lack of accountability is more on the juvenile delinquency cases because of all the reasons that you've laid out. And am I kind of?
Yes, but I'm gonna.
Yeah, no,
do a little.
I want to make. I'm trying
Yeah.
to make sure I'm understanding.
So raise the age would increase the 19-year-olds who for misdemeanors, right?
Yep.
Like 18-year-olds would go directly into family court.
Yep.
And could be under that umbrella of family court. Unless there's different legislation that comes, youthful offender, what makes you eligible to get in it, how you get into it, which way you get into it. We don't have to get into all of that. That would not be impacted by, just adding another in that, like that would all still work the same way. If 19-year-olds, now I just have to check my chart.
Yeah.
To make sure. So if essentially raise the age, now say 16 to 19, right? Misdemeanors again would not be able to transfer, those would stay.
Yep.
But felonies could still transfer,
Yeah.
youthful offender. So it really would not impact that. Now, on the youthful offender side, the ultimate accountability is that the case could move back to criminal court, and then you have your criminal conviction on your record, and then a really important thing I want to underscore for a youthful offender, they too still need to engage on the family court side. So until that case goes over to criminal court, the family court has to hold certain hearings. If they decide there's been violations of probation, there's a motion to revoke their status in family division. Until that happens, that case can't move back to criminal court. If that youthful offender doesn't show up for that violation hearing or that revocation hearing, the case can't move back. And so we have situations, and I was just emailed about this yesterday while you all were taking testimony, that a state's attorney has had this happen just recently, where a youthful offender wasn't showing up to various court hearings. An arrest warrant was issued. The youthful offender passed the age of 22. Jurisdiction in family division ends at 22.
So I need to understand.
They aged out of youthful offender, and that case is gone. It cannot go back to criminal court.
Tell me real quickly before, is it in statute that they have to be there for the revocation?
Yeah, I mean, this is a due process. This is embedded in due process. They have to have notice of the hearing, and then they need to be, part of the hearing. So it can't go back.
So No, I understand due process, but where, I mean, it's like they have the benefit of going into the family court. And if they mess up, they can be kicked over to the criminal court. I don't understand where you would have to have the notice and opportunity to be heard on that. You just do, is that been
It's-
established in case law?
It's in the statute, what is required, the revocation hearing that needs to occur in the family division, like their status, so they've been brought into as a youthful offender. That's been decided for them to no longer be a youthful offender. That has to be decided in family court after a hearing, and that's in statute. So the judge can't do it unilaterally. And so we have had situations where individuals have aged out.
So why couldn't we do? I mean, that's very problematic. So, but it would seem, I mean, could it be a ex parte, meaning they're not all the parties, hearing that sends them over to juvenile court with a scheduled hearing 2-3 weeks later, and they can show up, and if they don't show up, tough luck, no, still due process violation?
I think that would be a larger conversation of how that could be done without creating constitutional violations. So I don't know the answer to it.
That'd be something that I think we should look into.
It would be a conversation.
Sorry.
No, go ahead.
Is the reason that happened, like, so if these things are supposed to move fairly quickly and they age out at 22, like, was this case brought when this person was like 21 and like 6 months and is this a very specific situation where like how I'm just trying to understand, or is it because maybe it wasn't happening really quickly and it took a long time?
That's a great question, and I do not know the specifics, so I will dig into that a bit more. What I think is important with that range of time to remember are a few things. One, the court has jurisdiction to 22. That may not be that individual's plan. So let's say a successful youthful offender, however they got there, again, we won't sidetrack with that. Say they were 18, it takes 6 to 9 months, maybe it's a complicated case to get to disposition. So they're a little bit before 19, they have their disposition plan. It looks like it'll take about 2 years to do that, that's approximate. They get everything done, and they get everything done before 2 years, the judge can close that case, like success, done, right? They don't have to hold anything to 22. On the flip side of an unsuccessful case, say that same person, again, came in as YO 18, disposition took a few months.
Yeah.
The plan was only for 2 years, but there's lots of trips along the way. Like this happened, violation of probation, maybe that comes in. Okay, it's not enough to revoke the person. Like, let's keep working with this person. And then have to tell you, those involved in the juvenile system, like really, really want to work with these individuals. And there are a lot of chances given. Judges do not revoke YO easily. The rare exception would be committing another crime, like Judge Zone said, like something like violations of their juvenile probation. It's going to take a fair amount or again, very serious circumstances to push a judge to say, after a hearing, this status should be revoked. So sometimes that person who maybe was only going to be on juvenile probation as a youthful offender for 2 years, that could become 3 years. And then the behavior is maybe getting worse. And then maybe they check out and they miss a few hearings. And then we're having months to stack up, and then you can get to 22. So I will find out because that's not the only situation. I've had this aging out on the juvenile delinquent side and on the youthful offender side. It's not a singular situation, but I'll try and get more of a timeline for that particular case for you before next week.
I just want to be perfectly clear before I start.
Yeah.
This is my own observation, my own opinion. I think prosecution, because your defense, right? Prosecution is always, it's basically thrown out, we always want to prosecute. We don't want to give anybody too much of a chance. We want to throw the book at them, incarcerate, the whole 9 yards. I think what I'm hearing from you today, I could be wrong, is you have a toolbox, you're willing to use it, and you're willing to expand that toolbox to try to work with somebody that wants to work with us to try to reset their life. Is that correct?
Yes, I would say the statement at the beginning is a stereotype that I would very much push back on, that idea that like prosecutors just want to charge up. We just want to
Like
put
I said,
everybody.
that was my own,
Yeah,
that's my words. That's why I phrased it, that this is,
yeah. Yeah, no, I do not think that is accurate. And we'll for now just say in the juvenile justice context, we don't want these juveniles to show up on the criminal court side. We don't want to see them in a few years, whether we're seeing for them for the first time at 16 or 18. Our whole hope is that whether it's a delinquency proceeding or a youthful offender proceeding, if appropriate, like we want them to be rehabilitated. We don't want to see them again on the adult side. So it's to our benefit, right, to be working and figuring out which route will benefit this youth. But yes, the engagement is critical. And again, 17 and under, there's more to keep them engaged. Over 18 is just where we struggle with that. If they do not wish to engage, we have a very hard time holding them accountable unless another crime is allegedly committed, and then we have our other route of criminal court.
thank you.
Karen, and then Angela, unless it's following up with what Ken just said.
No.
Okay, yeah, Karen. then-
I appreciate that that's the piece that I was going back to, of saying how there's limited tools once somebody is 18. But feels like what I'm hearing is the tool is the criminal justice system. It works. And I feel like that's important for us, right? That's not necessarily the tool that we want to use. And so I think we're hearing all about how the juvenile justice system is holding folks accountable. And it's really laid out in that kind of messy, complicated way of those graphs and things. So if you can remind me, like, what are the types of crimes that we're looking at that get people in the juvenile justice system? Because if they're committing more serious crimes, they're not eligible for the system in some ways.
Well, just to remember, then again, all the charts, of what is eligible for what, for our 16 to 18-year-old group, the felonies that fall outside of the big 11 plus 3 that you've heard about, those felonies they can start in criminal court.
Yep.
And they can be moved to YO. And that was one of the questions of violent felonies. So, and I don't know if that's what you're pointing towards, of like, so some of those are very serious crimes that, we prosecutors are agreeing to send to YO when we think that's appropriate.
Yeah, that's the piece that I'm guessing I'm trying to understand is it seems like there's lots of options that youth comes in who is 18 and is showing a lot of risk. It's like, okay, so maybe you're not going to get the family, you're going to get transferred up. So I just am trying to understand why the question is saying that there aren't the tools, because isn't that decision made at the beginning? So is it more that training needs to be done so better decisions are made where folks are placed?
Well, so going, I think, to your original question, currently for 16 and 18, for misdemeanors, there is no option. Those are
Misdemeanors.
right. So a misdemeanor could be domestic assault. Serious crime, it's a misdemeanor. It is a complicated crime. The underlying behavior to work through that and to rehabilitate someone who has that sort of power and control embedded side of domestic violence, that takes a lot of time and resources to tackle. So say that 18-year-old comes in and the disposition plan in juvenile court is you need to do domestic violence counseling. One issue that I was going to bring up later, and it's perfect now, that age group, and I wish I had gone before DCF because I think this is a good question for DCF, but you can ask them next week, is for that 18, 19-year-old group, they're too old for the child-oriented services, and they're sometimes too young for some of the adult programming. One issue I ran into regularly with that age group of, and again, my fact, sorry to always lean on domestic violence, but that's where I'm most comfortable. 16, 17, 18, 19 years old, the 16 and 17-year-olds, DCF and the community might have some resources for them for that counseling piece. The 18 and 19-year-old individual counseling available with time delays, but available. Group counseling, that would be, somebody's on somebody's probation condition as an adult, completely inappropriate for an 18, 19-year-old to sit in a group with 30, 40-year-old folks convicted of domestic violence. Like, it's just not, and no one would want that. So I do think there's a space there where there's likely programming that's missing for that young adult age group. Yeah.
I guess I would just be curious for the numbers of it, of rebalancing the whole system for a small group versus is it more about training to make sure that juveniles are getting put in the right spot, juvenile, criminal justice, or youthful offender first. So I guess it'd be helpful if there are numbers to that. I appreciate the stories, but hearing the numbers would be helpful.
Yes, and we definitely heard that loud and clear yesterday of data and throughout the testimony, really understandably wanting data to wrap around. And I know I think it was Judge Soni who mentioned it, maybe Attorney Paul. One of the issues with data and the juvenile system is that once the case is disposed of, it goes away. So we do struggle with some of the data collection looking back. But I can try to see what we can pull together as far as, to your point, at the beginning, like where things are going. But again, for these currently, for the 16 to 18-year-olds, the misdemeanors, we don't have discretion right now. They're going into family court and only, we can't bring them to criminal court for the 18-year-olds on misdemeanors.
Angela, then Ken.
And I'm trying to think about this holistically, and so this isn't a perfect question for you. But so it's one of those like in your experience, in your opinion kind of questions. When you say, I've heard you say a number of times that there's that age group that just, if they don't want to engage, they're kind of lost to the system and circumstances and like, what can we do? And I'm wondering how we're trying to engage them. Like, are we trying to engage them in a way that 18 to 20-year-olds would find engaging? Like I think about classrooms, not a teacher, but I'm on a school board and have heard a lot about classroom management but just thinking about kids in general, like it's very easy sometimes as adults to say like, well, it's just they're just not doing what I'm asking them to do. And you don't examine what you're asking them to do and make sure that it's age appropriate. And so again, not like something that the prosecutors would be doing wrong, but just wondering, are we employing the right engagement opportunities?
It's an excellent question, and it actually was in my notes. So something on my mind when presenting to you today. I think and again, this is a critical question likely for DCF, for the caseworkers. As they mentioned yesterday, they are not trained probation officers. They're social workers, and they're wonderful at what they do. And there was mention of, caseloads and whether they're going up, whether they're going down. And one of the thoughts I had when hearing about the caseloads and like the 18-year-old shouldn't be causing so much trouble was if you don't have some sort of consequence, right, hanging over, how are you engaging those 18, 19-year-olds? It's through relationships, right? If you can connect with that 18, 19-year-old, if the caseworker can find, some common ground, can find something they're interested in, something they're passionate about. Is it sports? Is it music? Right? Maybe there's a way. And I think the really good caseworkers who can figure out, that brain, that part of time in life, like how to get them excited. Like, I know you don't want to do the work application, but if you do, like, hey, here's the, little benefit that I know you're going to like. That takes a lot of time. And so one question that's been on my mind is that when folks are saying, I don't see why the numbers, like the 18-year-old shouldn't be, the numbers seem to be going down. Like, what's the problem? Anecdotally, watching caseworkers and hearing about different cases, I think they're spending a lot of time trying to engage, right? Trying to find them, trying to find where they're at, trying to pull them along. And that takes a lot of time. And so I think it'd be interesting, right, if we were able to get that granular, like case by case, like how many hours a month are you spending on the 16-year-old cases versus those 18, 19-year-olds? I'd be really interested to see what that difference might be. And I do think there is a training piece there, and I'm not going to tell anyone how to do that training, but anyone, again, who's worked with children and young adults, 14 and 15-year-olds, you're communicating very differently with them than 18, 19, 20-year-olds. And again, for the most part, DCF caseworkers trained and educated and then focused on the under 18 set. So what training, what additional tools potentially, if they're going to be working, they are working now with 18-year-olds, if they're working with 19-year-olds, what would they need to get that engagement? It's a great question. And I do think most of it's around relational building. But that's fully an opinion.
Yeah, no, it makes sense. And it makes me think about, working efficiently and I totally understand your point that it's incredibly time intensive. And with the caseloads that we were hearing about, like really not even practical or realistic. So then I wonder, maybe there are partnered, whether it's community partners or I don't know, other agencies, I don't know, but maybe there's a missed opportunity somewhere in there to work with groups of people who already have that training or already know how to engage with that age group. So just thinking about my friend who always says work smarter, not harder. And I know she didn't make up that phrase, but that's what I'm thinking about as you're talking. Like, how do we work smarter, not harder, and to the benefit of everyone involved, especially the young people.
Yeah, and we've all seen it. There are those people who are sort of the teenage whisperers, right? They just know how to talk to each other, how to engage, how to connect. And that age group, right? They're going to respond to emotional, relational connections. They're not in their rational part of this is a good thing for me to do, right? That's just not, that's the reason, that was part of the reason. And I think what's important, right, is if we're thinking about that brain development on the side of, we want to move them outside the criminality side, you have to consider that brain development piece with how are they engaging with these disposition plans. Again, if they don't, if they're not thinking long-term, if they're just thinking short-term, if they're being impulsive, that same brain, right, we're asking them to do a lot on these disposition plans. And if they don't have to, if there's no real world, consequence that makes sense to them, that matters to them, right? then those who don't want to aren't going to.
So before we have a couple of, doing a time check, I know yesterday you had a hard stop at quarter after, it's already 20 after. Or do you
So
not
the-
have the same hard stop?
The only thing I need to do, and I'm so sorry, I just have to text and make sure my son got off the bus because he was supposed to text me. And so that was the arrangement for today.
But we will have a stop at, very, so there's
That
not.
would be great. Because he does have basketball practice tonight, so, you know,
Miss that.
all of it.
Is that okay to go till 4:30?
4:30 is fine, yes. Just double check. Him and the dog are okay.
So Ken had a question and Tom had a question.
So how long does it take to transfer a case from family court to criminal?
Mm.
I was under the impression it takes a long time.
So if a case is in family court and there's been a motion to transfer it to criminal court, is that the,
Yeah, or just,
So if we could break it down to that question and YO for the, if there's a.
for the
probation.
revocation?
Yeah, the revocation, if you could tell us on both those.
I would not be able to give you fine tune, like I could not say like, oh, that's a month or that's 2 months. It would vary from county to county. And it's all the court calendar of when and how much time they would need and when attorneys are available, right, to have those hearings. So it could happen maybe 2 weeks after it's requested, or it could happen a month after.
I guess what I'm looking for a little bit more in my simple mind, not being a lawyer, is I assume you're taking it, you're trying to work with the individual. We're going back right back to where it was. You're trying to work with that individual. So before you take them out of the youthful and send them to the criminal, you're trying to get trying to give them as much way as possible to keep them out of criminal. Is that a fair assessment?
Many chances, assuming there's been no major change in the behavior, meaning like if suddenly things get very unsafe,
Yeah.
right, that pushes the request
No, I,
sooner, right? And then and an important thing to remember is that even if I make a motion to revoke a youthful offender status, and even if the judge finds like, oh yeah, you're not doing X, Y, Z, the judge has options and it's not just revoke. The judge can continue juvenile probation and change the disposition plan, could revoke, like there's 2 options that the judge has. So just because it's requested, and the judge can find that there was no violation, maybe there's not enough evidence to show that they've done the behavior that we're saying would, be the basis for a revocation.
I got you.
Yeah.
Thank you.
I'm going to retract my question
Okay,
for now.
other questions, or did you have more points that you also wanted to?
Just gonna run through because through your questions have actually pulled out, which is great. I mean, it's wonderful. So just to run through. We really wanted to highlight the engagement piece. I think you all have heard that. There. Thought I was getting a letter. Well, I guess I would just ask the committee, do you have any other questions, or are you feeling somewhat comfortable with the differences between delinquency and youthful offender? Feels like, I know, so I don't want to retread on that. It feels like you, okay, great. No, I think I've highlighted what we wanted for today.
We'll have more opportunity to weigh in on these issues next week.
Exactly. Like I said earlier, I'm reserving all of our arguments and corrections for next week. And we definitely have heard the request for data. And as I mentioned yesterday, the judiciary that's where we would be pulling a lot of the data from. And it may or may not get to everything that you want, but we're also reaching out to our counties to see if we can have a few snapshots for you next week, because I think that'll be really helpful. And again, to Representative Gosselin's question earlier, I think in those snapshots, you will see the discretion used not to push the most restrictive option when you see those snapshots. So I think that'll be really helpful for you all to see.
Thank you very much. Thank you. So we're adjourned until tomorrow. What do I have? 10 minutes after the floor?
So 10:30.
Said 10:30?
think the agenda says 10:30.
All right.
And because of that, I need some morning meetings.
Okay, well, we're adjourned until tomorrow at